Good morning, this is your Kelso Report for Monday, March 5th. I'm your host, Clark Kelso. We've got 4 cases today dealing with removal, water law, administrative law context, limitation of actions and suits against government, and human resources in a government context. First, we begin with the Ninth Circuit case involving removal. In State of Nevada versus Bank of America, the Ninth Circuit reiterated its relatively recent holding in Washington versus Kimai Inolux Corporation, a 2011 case, that there is no federal basis for removing a state attorney general's parens patriae action under state law pursuant to the class action prong of the Federal Class Action Fairness Act. The case had originally been filed by the Nevada Attorney General in state court, but had been removed by the bank. As the court noted, a parens patriae action bears some similarities to a class action, but it remains in form and reality an action by the state, not a class action prosecuted by private parties. So the class action prong of the Federal Act does not apply. For similar reasons, the mass action prong of the Class Action Fairness Act also does not apply to a parens patriae suit. Finally, the court held that the state law deceptive trade practices claims were truly state law claims, even though it might be necessary to construe federal banking law in order to determine whether certain representations and claims were truly misleading. This type of ancillary reference to federal law does not change the fact that the claims were based only in state law. Accordingly, the Ninth Circuit remanded the case back to state court. Next, a long-running water dispute in California. The issue before the Ninth Circuit in San Luis and Delta Mendota Water Authority versus Bay Institute was incredibly narrow and technical, yet of tremendous importance to the party. Essentially, the question was whether the Department of Interior properly accounted for the releases of water from the Nimbus and New Melones reservoirs back in late June 2004 under the Federal Central Valley Project Improvement Act. According to the plaintiffs and the Ninth Circuit dissenting judge, the accounting methodology, which managed to avoid a cap placed by Congress on releases, was a purely post hoc, arbitrary rationalization by the Department of the Interior when it realized it would run out of water for that year. But according to the District Court and the Ninth Circuit majority, Congress had granted the Department discretion to adjust the accounting methodology, and applying the Administrative Procedure Act's deferential standard of review, the courts affirmed the Department's methodology. It ends up being really an Administrative Procedure Act case with strong deference given to administrative expertise. Next, a case under state law, limitation of actions in suits against government. Now, as you all know, the processes for suing a government agency are well defined by statute and are designed to ensure both full exhaustion and timely presentation. In D.C. versus Oakdale Joint Unified School District, the 5th District faced the question of how to interpret Government Code Section 946.6, which has a 6-month limitation period for a claimant to file an action in court following a final denial of a claim by the agency. Well, the agency in this case denied the claim on May 10th, but did not send the claimant a letter giving purported notice of the denial until 1 month later. And the letter did not identify May 10 as the date of the denial. The claimant filed its action in court on December 3, more than 6 months after May 10th, but less than 6 months after June 9th when the letter was sent. The 5th District held that the date actually does start to run on the day of the decision because that is what the statutory language provides, but held that an agency must include that date in its letter in order for the letter to constitute proper notice to the claimant. A nice compromise decision. The court sent the case back to the Superior Court for further proceedings on the merits. Final case today involves human resources issue in the teacher context. Section 44909 of the Education Code authorizes the hiring of credentialed teachers for categorically funded projects. Because categorically funded projects rather obviously can go away suddenly when the funds run out, Section 44909 has a special provision that allows the school district to terminate such employees as though they were temporary employees when the funding runs out or the contract with the employee comes to an end. In Stockton Teachers Association versus Stockton Unified School District, the district hired 9 credentialed teachers, ostensibly pursuant to Section 44909. But the contract with the teachers was rather ambiguous about which categorically funded project, if any, they were being hired for. In the case of one of the teachers, the program she apparently was hired for was clearly not categorically funded. In any event, all 9 of these teachers were summarily terminated in the middle of the year because of budget problems, and their terminations were not timed to the end of their contracts or to the end of funding for the categorical program. Stockton was having budget problems, but these categorical programs were funded. Well, in these circumstances, the 3rd District held that the teachers must be accorded the notice and hearing protections given to probationary employees, which is the default classification for an employee in the teacher context. Section 44909 permits a district to terminate summarily only in the narrow circumstances of the end of the categorical program or at the end of the employee's contract, and neither of those circumstances existed in the case. Well, that's it for today's Kelso Report. Have a great day in the law.